And in this webinar, I'm going to take a look at the Charity Commission's powers of investigation and how and when they can be used. Then my colleague Kye will talk to you about a recent case study that provides a good example of how contact with the Charity Commission can escalate to a full statutory inquiry, and hopefully that will provide some useful guidance as to why early engagement with the Commission is really important. So we've just set out on this slide the agenda for today, and we're going to start off just by covering some of the basics in relation to the Charity Commission. So I'm sure that you all know all of this already, but just in case you don't, the Charity Commission is the registrar and regulator of charities in England and Wales. It is an independent, non-ministerial government department with quasi-judicial powers accountable to Parliament. It is, however, independent of ministerial influence and control. The Charity Commission has declared its ambition to be the expert charity commission that is fair, balanced and independent so that charity can thrive. And in seeking to achieve that ambition, it has 5 priority areas of focus. This includes that it will support charities to get it right, but take robust action where it finds wrongdoing and harm. And that's the area of priority that's most relevant to what we're going to have a look at today. So the Charity Commission has a number of statutory objectives and functions, and they all feed into why does the Charity Commission carry out investigations. So I've popped up on the screen there the statutory objectives of the Charity Commission. And I'll just run through those very quickly. So it's to increase public trust and confidence in charities, and this is a key area of focus really, to promote awareness and understanding of the operation of the public benefit requirement, to promote compliance by charity trustees with their legal obligations in exercising control and management of the administration of their charities, to promote the effective use of charitable resources, and to enhance the accountability of charities to donors, beneficiaries, and the public. So in carrying out its statutory functions, the Charity Commission has a number of in carrying out its statutory objectives, the Charity Commission has a number of statutory functions. And I've identified here on the slide the one that's most relevant for us today, and that is identifying and investigating apparent misconduct or mismanagement in the administration of charities and taking remedial or protective action in connection with mismanagement or misconduct in the administration of charities. So you're going to hear misconduct and mismanagement in the administration of charities quite a lot throughout this presentation, and at the end I'll talk a little bit more about what that really means. So just a very quick note in relation to exempt charities. So these are charities that are exempt from registration with the Charity Commission and are not directly regulated by the Commission because they generally have a different principal regulator. So for example, multi-academy trusts are an exempt charity. They're regulated by the Department for Education. Universities, they're regulated by the Office for Students, and some national museums which are regulated by a government department. So exempt charities are still required to comply with charity law, and their principal regulator must promote such compliance. So for exempt charities, some of the points I'm going to talk about today are not going to be directly relevant as their principal regulator will deal with any lower level issues. However, should be kept in mind that the Charity Commission can get involved with exempt charities and can use its powers and open a statutory inquiry if the principal regulator asks it to do so. So, moving on, how does the Charity Commission identify issues that might need further investigation? So the Commission's focus is on the conduct of trustees and their leadership of charities, always with the overriding concern being to ensure that public trust and confidence in charities is maintained. There are a variety of ways that the Commission might become aware of an issue. I've popped some of the most common ones up on the slide, but there are other ones as well. So I think some of the most common ones are information that's actually contained in the charity's annual return and accounts. For example, you might have included there a payment or other benefit to a connected person or a trustee that the Commission might want to look at in more detail. The Commission's own proactive work So, for example, the case study that Kye will talk about in a bit starts off with the Commission's own proactive monitoring in relation to charities that operate in high-risk areas. Trustees filing serious incident reports can bring incidents to the attention of the Commission. Generally speaking, a serious incident report is seen as a sign of good management by trustees, but it can, of course, identify issues that the Charity Commission might want to have a look at further. Complaints from the public and media reports. So this feeds into the Commission's concern around public trust and confidence in charities. And if a charity finds itself at the end of the Daily Mail treatment, it's much more likely to find itself also under the watchful eye of the Charity Commission. I thought it might be helpful to just share with you some common themes that pop up time and time again in investigations. Many of the investigations start by a charity regularly failing to file its annual return or its accounts. The other key areas where the Commission is likely to get involved is where there's financial mismanagement or lack of control of funds, and also where there's mismanagement of conflicts and benefits. So once the issue has been identified, the Charity Commission takes a risk-based approach to deciding what the next step should be. And this is intended to make sure that everything is looked at, but then the Commission focuses its resources on those issues that are most likely to cause harm. The Commission will think about the impact of the risk and also the likelihood of the risk materialising. It's important to keep in mind that as part of the risk assessment, the Charity Commission can look at the conduct to date of the trustees and consider whether they feel they've acted honestly and reasonably, or whether there's a concern about reckless or willful wrongdoing, or perhaps just being less clear than they could be, less helpful than they could be. So once an issue has been identified, what is the Charity Commission going to do about it? So as a starting point, the Charity Commission has access to a number of general regulatory powers that it can use to further investigate a matter. I've popped up on the slide the key powers there. I'm not going to talk about all of them, but I'm going to pull out some of the key ones there. So as a first step, the Commission is likely to want to gather more information about the issue and about its potential impact. And the Commission can issue orders requiring any person to provide it with documents or information that's under their control. The Commission can also issue advice and guidance on the particular matter, and any trustee who acts in accordance with that advice and guidance is generally considered to have been acting in accordance with their trustee duties. If trustees are unsure how to act, they can ask the Commission to provide advice and guidance, and this can be a helpful step if things have gone wrong and you're not quite sure what to do. You can ask the Commission for some help there. Where the Commission considers that charity property is not being applied for the purposes of the charity, it can issue an order requiring those holding the property to apply it for a specified manner. Then moving up to the next step, if the Commission considers that the trustees have been in breach of duty or to have committed misconduct or mismanagement, there goes that phrase again, then the Commission can decide to issue an official warning. Before issuing an official warning, the Commission must give notice to the charity and each trustee, which should include details of the actions needed to rectify the issue, whether and how the official warning will be published, and the period for any representations to be made about the content of the official warning. It's probably worth mentioning at this point that failure to comply with an order or failure to take the rectification steps identified in an official warning might be viewed by the Charity Commission as evidence of misconduct and mismanagement in the administration of a charity, which could lead ultimately to trustee disqualification or the Commission opening a statutory inquiry. So it's important that if you reach the stage where an official warning is being made, that you do take that seriously and you do follow the steps set out in that official warning. The Charity Commission also has a power to disqualify a trustee for up to 15 years, even before a statutory inquiry has been opened. So to use that power, the Commission needs to be confident that the person is unfit to be a trustee and that it's in the public interest to make the disqualification order, and at least one of the following conditions is met. And that is that the person has been cautioned for an offence against a charity or in the administration of a charity for which a conviction would result in automatic disqualification. So, for example, if they're cautioned for a money laundering offence or perjury or contravening an order or direction of the Commission. The person has been convicted of an offence in another country that would trigger automatic disqualification if convicted here. HMRC has found the person to not be a fit and proper person. The person is responsible for or knew about and failed to take reasonable steps to stop misconduct or mismanagement in a charity. And that same applies if you're the employee of a corporate trustee. And then the final power or condition that can be used to disqualify is that the person has engaged in any other past or continuing conduct, whether or not in relation to a charity, that is likely to be damaging to public trust and confidence in a charity or charities more generally. And this last one is really incredibly broad and causes some concern, I think, amongst practitioners about how that power should be used. It has the potential to be triggered by actions that have been taken before you became a trustee. So in a recent case, a trustee was disqualified for 2.5 years due to historic social media posts. He actually became the first person to successfully overturn their disqualification at the first tier tribunal. But I think this is an interesting area to keep an eye on. I think it's also worth noting that in that particular case, the disqualification, the investigation and disqualification came about because the press reported on the social media posts that had been made historically. So just something to keep an eye on there. If the steps that the Charity Commission has taken under the general regulatory powers haven't resolved the issue, then the Charity Commission can, of course, move on to a statutory inquiry. So the Commission has power under Section 46 of the Charities Act to open a formal statutory inquiry into a charity. This is generally reserved for the most serious issues and those that pose the greatest threat. And it's really seen as a very serious step indeed. So the sorts of issues that might give rise to this are a significant financial loss for the charity, serious harm to beneficiaries, links with terrorism, serious illegality, significant private benefit, where a trustee or connected person, for example, is taking a significant amount of money from the charity that hasn't been authorised. Lack of independence, that's independence of the trustee board in how the charity is being governed, and any other issues that could impact significantly on public trust and confidence in charities. So whilst a statutory inquiry can come about after a lengthy period of engagement, and again, Kye will talk a bit about that in his case study, it can also come about without that lengthy period of engagement if the situation is serious enough. Once a statutory inquiry has opened, the Commission has access to enhanced powers of investigation. These enhanced powers of investigation include directing a person to provide a written statement on a matter, returning answers in writing to the Commission on questions, and verifying those statements with a statutory declaration, providing documents under your control, and attending at a specified time and place to give evidence or produce any documents. So the Commission can also take evidence on oath and require a person being examined to make a declaration of truth. I think it's worth mentioning at this point that if you do find yourself in a position where the Commission is essentially interviewing you as part of the investigation, that can be incredibly stressful for the person involved, and they are likely to need quite a lot of support. The process can be quite lengthy, and we would strongly recommend that they have a lawyer or some other support as part of that process. Once a statutory inquiry is open, the Commission also has the power to enter premises with a magistrate's warrant and seize documents and other electronic devices. So you can see that the types of actions the Commission can take have really ramped up once the statutory inquiry is opened. The Commission also will then have access to temporary protective powers. These are a range of powers that are intended to protect the charity and its assets while the Charity Commission carries out its investigations. And they can include suspending a trustee, officer, agent, or employee at a charity, and also suspending them from their membership at the charity if needed, appointing additional trustees, vesting any property in the official custodian, ordering anyone holding property not to part with it without the Charity Commission's approval, restricting payments that can be made without Charity Commission consent. So, for example, freezing bank accounts, and that is used reasonably frequently by the Charity Commission, pending the outcome of an investigation. The Commission can also appoint an interim manager to either act with the charity's trustees or instead of the charity's trustees. So interim managers are appointed from the Charity Commission's list of approved practitioners. I'm on the list, and so is our head of charities, Liz Brownsall. Finally, the Commission can also order a trustee, officer, or employee to take or not take any specified action. To use a temporary power, certain conditions have to have been met, and that is either that the Commission is satisfied that it's necessary and desirable to protect the charity's assets, or one of the following has been met. That is a failure to comply with an order or direction of the Commission, a failure to remedy any breach specified in an official warning, or any other misconduct or mismanagement in the administration of a charity. So again, failing to comply with an official warning, failing to comply with an order or direction, it can have serious consequences further down the line. And we would strongly recommend that you engage early on in those processes to avoid that situation arising. The Commission also has access to permanent protective powers, which are intended to be much more long-lasting. I've again put some of these on the slide for you. I think the most important ones perhaps are the removal of trustees and the winding up powers. So the Commission can at this stage remove a trustee, officer, agent or employee who has been responsible for or knew about or contributed to misconduct and mismanagement. Before exercising this power, the Commission needs to be satisfied that there has been a failure to comply with an order or direction to remedy a breach specified in an official warning or any other misconduct or mismanagement, and it is necessary and desirable to protect the property of the charity. Notice needs to be given to each of the trustees, and the order can apply even if a trustee has resigned. So you can't get around being removed just by stepping down from your post. It should be borne in mind that if you are removed as a trustee, then the trustee is disqualified from being a charity trustee of any charity and from being employed as a senior manager in a charity. And failure to comply with that disqualification is a criminal offence. Finally, it's also worth keeping in mind that an order removing an individual from their trusteeship can be challenged in the first tier tribunal. So if the Charity Commission is satisfied that the charity does not operate or its purposes would be better furthered if carried out by another charity, the Commission can actually order the winding up of the charity and its assets to be transferred to another charity with the same purposes. The Commission must give public notice of this intention and generally allow 60 days for public representations. So in a extreme case, if things have really gone wrong at the charity, the trustees can find themselves removed from that charity and the charity closed down. So whatever they might have set up and they might have been trying to do, they will then essentially lose control of that and someone else will be furthering those objects. So some other points to note. We've talked quite a lot about misconduct and mismanagement. It pops up all over the place as one of the sort of gateways to using various powers. But interestingly, there is no statutory definition of misconduct and mismanagement. So the Charity Commission has said what they think those words mean. They've said that misconduct is defined as any act or failure to act in the administration of the charity, which the person committing it knew or ought to have known was criminal, unlawful or improper. And mismanagement includes any act or failure to act in the administration of the charity that may result in significant charitable resources being misused or the people who benefit from the charity being put at risk. However, the first tier tribunal has said that these definitions, whilst providing some guidance, cannot restrict the ordinary meaning of the words. It was held that the words must be viewed in their context and would encompass a failure by a charity trustee to act as an ordinary prudent man of business, both in terms of process, i.e. how decisions are made, and substance, i.e. what decisions have been reached. It's also worth noting that certain acts stemming from involvement with the Charity Commission and its investigations can amount to a criminal offence, which I briefly mentioned already, but there are additional criminal offences. For example, knowingly or recklessly providing false or misleading information to the Commission, or willfully altering, suppressing, concealing or destroying any document required to be produced to the Commission are both criminal offences, punishable by a fine or up to 2 years in prison. In addition, if any individual has disobeyed an order or direction of the Charity Commission, the High Court can find that individual to be in contempt of court, and criminal penalties can apply, including up to 2 years in prison. And the Commission has pursued this option against charity trustees in the past, obviously in the most extreme of cases, but it's worth just bearing in mind. Finally, I think it's also worth just bearing in mind that many of the decisions of the Charity Commission can be challenged in the first tier tribunal. Historically, perhaps it was rare to challenge a decision. However, the Charity Commission appears to be using its powers more frequently and with a more robust approach. As a result, I think we're likely to see an increase in challenges, which may actually be helpful. It may provide greater insight into how and when the Charity Commission should really be using its powers. So I'm now going to hand over to my colleague Kye, and he's going to talk you through a really interesting case study.
Jen. So as Jen's mentioned, I thought it might be really helpful to go through a statutory inquiry, just to put some of the concepts that Jen has been talking through into perspective. So the statutory inquiry I'm going to talk about was released in May 2025 and relates to the Olive Grove Foundation. So this is a charity whose objects are to prevent or relieve poverty, to relieve financial hardship worldwide, to assist young people to advance in life, to promote sustainable development by the relief of poverty and the improvement of the conditions of life in socially and economically disadvantaged communities. So as Jen has mentioned a little bit earlier in the webinar, the Commission is quite an active regulator. So in this case, the Commission has actually had quite a long period of involvement with this charity. So the Commission initially got involved with the charity in 2019 when it proactively undertook a monitoring inspection of the charity. This was due to the charity's international operations and expenditure in high-risk areas, including Syria. So as the Charity Commission is quite an active regulator, they do get involved with charities, especially when they're operating in high-risk areas where the charity is more vulnerable to abuse. So as part of its monitoring inspection, the Commission reviewed the charity's policies, financial records, and they identified some regulatory concerns into the ways in which the charity was governed, how it was managed, and the administration of the charity, which include the charity's overseas activity. So later in 2019, the Commission closed its monitoring case and issued the trustees with some regulatory advice and guidance. And in closing the case, the trustees were told that the Commission would re-inspect the charity in 2020 just to make sure that the trustees had acted on the regulatory advice and guidance that they provided. So the trustees were well aware that the Charity Commission was going to get back involved at some point in the future. So as the Commission said, they did re-engage in 2020, to assess whether the trustees had acted upon the previous regulatory advice and guidance. And having met with the trustees again and reviewed the charity's records, the Commission concluded that the trustees had not actually adhered to the regulatory advice and guidance that they'd given, and the Commission still had some serious regulatory concerns. And because of this substantial involvement and the lack of sort of progress, the Charity Commission opened a statutory inquiry into the charity in 2021. So I thought it'd be helpful to just talk through some of the key findings in the statutory inquiry. So as a result of the monitoring inspection in 2019, the charity had implemented a number of policies. So this included conflicts of interest, expenses, financial management, and safeguarding. However, the Charity Commission considered, because of the size of the charity, its level of income, and its overseas activity, that the policies were not comprehensive enough. So, for example, the financial management policy in particular did not include any procedures for holding or transferring charitable funds overseas, which was a large part of the charity's operations at the time. And this is particularly important for the Commission, as the Commission had previously raised concerns around the charity's funds being transferred to personal bank accounts of the trustees in order to facilitate overseas transfers. So, as part of the inquiry, the Commission also found that the trustees had a complete disregard or a complete lack of understanding of the importance of financial controls and management. So, in 2019, the Commission provided advice and guidance on the use of personal bank accounts to transfer and hold charity funds. And despite this advice and guidance, the Charity Commission found that between January 2018 and May 2020, the trustees had allowed the transfer of more than 150,000 of charitable funds from the charity's bank account into the personal accounts of one of the trustees. So this was to facilitate overseas transfers. But one of the issues identified by the Commission was that some of the amounts that were being transferred into trustee bank accounts were not then all being transferred back out. So there was a real concern about the loss and the use of charitable funds. Additionally, throughout the inquiry, the Commission sought to ascertain whether the trustees had followed the previous regulatory advice and guidance issued to improve, create and implement policies in relation to the charity's activities. But despite being compelled to provide these by the Commission using its advanced powers, the trustees didn't produce anything. So the inquiry found that there was either a lack of any of these written policies, or the alternative, there was non-compliance with the direction on behalf of the trustees. The inquiry also found that trustees had failed in their legal duty and responsibility to ensure that the charity's annual account documents were filed on time, which is a legal requirement, as Jen said earlier. So for the financial year ending in 2019, their accounts were filed 42 days late. And in the financial year ending 2021, the accounts were filed 183 days late. So I think the key takeaways from an inquiry like this is that it shows the importance of actively engaging with the Charity Commission. You can't just sort of bury your head in the sand and hope that the Charity Commission will go away, because as soon as you've been identified and they've given you some advice, they will expect you to follow it. So I think sort of a takeaway is, if the Charity Commission reaches out to your charity, you should fully engage with them and seek professional advice when needed. The Commission is never going to criticise a charity for spending some of its money on getting professional advice when it's needed.
Brilliant. Thank you very much, Kye. That does bring us to the end of our webinar. We have had a few questions that have come in. Kye, do you want to take the first one?
Yes, thank you. So I can see there's a question that's come in that says, where can we find statutory inquiry reports? So the Charity Commission on their website actually have a list of all the statutory inquiries that have been published over the last 2 years. After 2 years, they're removed from the Charity Commission website, but they are then stored on the National Archive website, so you can still find them, the more historic ones. You can also sign up for Charity Commission alerts, which will tell you when a new piece of guidance or a statutory inquiry report is released. And I'd highly recommend signing up for these alerts, as they're usually full of really, really helpful guidance and tips, especially the statutory inquiry decisions, because they normally have a section at the very bottom which gives some guidance on the wider section, so sort of some advice to other charities to make sure that they don't fall into the same pitfalls that the charity that's had the inquiry has fallen into.
Yeah, really good points. Thanks, Kye. And we've also had a question come in about if someone has complained about you to the Commission, could the Charity Commission take steps to actually approve what you've done and say actually what you've done is okay? I mean, the answer to that one really is that technically, yes, they could issue, if needed, a Section 105 order saying that what you've done is fine and ratify it. However, I think in reality, the chances of you actually getting one of those orders is really quite slim. And I think really that just again comes back to the importance of early engagement and trying to get ahead of the narrative on some of these issues. Once things are in the public domain, whether that's via the press or via the Charity Commission making a public announcement, it's then quite difficult to get a hold of things. And damage can already be done to individuals and to the charities. So I think it's really a case of, if something's going wrong, someone's threatening to make a complaint, it is about taking steps early to try and shut that down as quickly as possible and involving the Commission where needed, perhaps by making a serious incident report so that you can, to the degree possible, you can control the narrative around what's happening and show the Commission how you're proactively managing things rather than issues coming to the attention of the Commission in another way. So I think that's all we've got time for, but I really hope that you've enjoyed the webinar today, and please do check out our website for any other upcoming charity webinars. Thanks very much.